Welcome back to another episode of our trademark video series exploring the ins and outs of IP protection. Today we'll walk you through the roadmap to the application process in Canada. That way you'll have everything you need to kickstart the trademark registration process. Let's dive in. Whether you're brand new to the world of trademarks or even somewhat familiar, you most likely have a couple of questions. Well, we have answers. First up, who can register a trademark in Canada? A person can file a trademark application on an individual basis or as a business. The Trademarks Act sets out who is entitled to the registration of a trademark. According to the Canadian Intellectual Property Office, aka CIPO, any companies, individuals, partnerships, trade unions, or lawful associations, provided that they comply with the requirements of the Trademarks Act and trademarks regulations, can apply to register a trademark in Canada. So how does the Act define what is registrable? The Trademarks Act sets out what is not registrable in Canada as a trademark. Let's take a look at some of those. Names and surnames, clearly descriptive marks, deceptively misdescriptive marks, words that represent a geographical location commonly known to be the place of origin of such goods or services, like wine that comes out of France or clothing that comes out of Italy. Words in other languages, words or designs that could be confused with a registered trademark or pending trademark, words or designs that look very similar to a prohibited mark. So what can you trademark in Canada? At this point in time, trademarks can be applied to words, designs, color as applied to a particular shape, size, sound, motion, certification marks, and distinguishing guises. If you're wondering what a distinguishing guise is, we don't blame you. Weird name, yes. Complicated, not really. A distinguishing guise refers to the overall appearance of packaging of a product that is used to distinguish said product from other items sold in the market. A great example of this would be the Toblerone packaging, which is a triangular shape. And we all know Toblerone, it's good, but you can always recognize the packaging. Speaking of distinguishing your brand from the competition, how do you know if your trademark is even available? It all starts with a trademark search. The deeper the search, the more accurate the results will be, and the higher your chances are of getting your trademark registration approved. Are trademark searches available or required by CIPO before filing an application? Naturally, a search is advisable to protect not only an applicant's initial application fee, but also any marketing investment that has been put behind a particular trademark. That said, CIPO does not require or provide trademark searches to the public. If an applicant can see a registrant with a very similar trademark, they may want to rebrand while they still can. The importance of searches cannot be overstated. Searches can reveal potential obstacles to registration, whether likelihood of confusion or other potential issues. Now that you've determined what you'd like your trademark to be, what information and documentation must be submitted to apply for registration? A trademark application needs to meet at least a minimum set of requirements minus any fine details in order to get a filing date and application number. The minimum requirements include the name and address of the applicant, the goods or services that the trademark will be or has been used for, either a statement of your intention to use the trademark or the date of when you first used the trademark in Canada, and the application fee, a representation of the trademark such as a drawing, unless the trademark is just word or words. Speaking of trademark drawings, what is the appropriate way to submit them? Well, the drawing must be no larger than 7 centimeters by 7 centimeters. The drawing must be in black and white and may not include anything that is unrelated to the desired trademark itself. Beyond the basics, you also need to decide which class or category your trademark falls under. So, are multi-class applications allowed? Currently, additional classes do not carry any additional cost. Once the new regulations come into effect, however, multi-class applications will still be allowed, but these will carry additional fees under the NISA classification system, which is being adopted. What are the fees? Currently, it costs an applicant $250 for the initial application and $200 at the end of the application process upon registration of the trademark. Once the new regulations come into effect, the initial class in an application will cost $330, plus an additional $100 per class. The registration fee will be eliminated. What if the applicant already has a foreign trademark application? If you already have an application in a foreign jurisdiction that is a member of either the World Trade Organization or the Paris Convention, you can take advantage of certain benefits in your Canadian application. So how does that work? Firstly, your application should cover the same sorts of goods and services as in the original application and be for the same trademark. The application must be filed in Canada within 6 months of the foreign filing date. A copy of the foreign application is not required to be submitted with the application, but it might be requested for examination. The applicant or their predecessor must have been living or be carrying on business in the country in which the foreign application is filed at the date of filing. With that being said, when the new regulations come into effect, the applicant will only have to live in or be carrying on business in one of the World Trade Organization member countries. If the examining authority raises objections to the application, can the applicant take measures to correct it? If the CIPO examiner finds grounds for a rejection, in many cases an examiner report will be issued, also known as an office action. The examiner's report will outline the objections raised by the examiner when reviewing the application. Common issues raised in examiner reports include likelihood of confusion with another registered trademark, an issue with the description of goods and services contained within the application. Do the goods and services emanate from Canada? Descriptiveness of the mark in relation to the goods and services. An application can be denied registration if the issues raised in an examiner report are not addressed in a proper response to the examiner. In Canada, only the applicant or a registered trademark agent working on behalf of an applicant can submit these responses to an examiner. Once issued, an applicant has 6 months to submit a response to an examiner report. If the response is found to be satisfactory, the application will proceed to the next step of registration. If the response to the examiner's report is not satisfactory, the applicant will either receive a further examiner report or an outright refusal will be issued. Can rejected applications be appealed? If so, what procedures apply? A rejected application can be appealed by the applicant to the federal court. The appeal will be heard by a single judge of the federal court. If that's not satisfactory, a further appeal can be made to the Federal Court of Appeals, as of right, and the Supreme Court of Canada, but only with leave by the Supreme Court. When does the registration of a trademark come into effect? Currently, once the notice of allowance has been granted by CIPO, the applicant must submit a registration fee of $200. This fee can be paid online to reduce wait times. Once the payment is received, the trademark registration process is complete. CIPO will then issue a trademark certificate to the registrant and add their trademark to the official database. How long will my trademark be protected, and how can a registration be renewed? Currently, trademark protection in Canada extends for a term of 15 years. With that said, as evidenced by the colonial from my previous video presentation, trademark protection can run indefinitely so long as the registrant renews the trademark. Once renewed, protection will again run for 15 years before requiring renewal again. The fee to renew a trademark in Canada currently is $350. Again, this will provide a further 15 years of trademark protection before the fee is due again. What is the usual time frame for filing to registration in Canada? The usual time frame for filing to registration, assuming no significant examination issues or oppositions occur, is 16 to 18 months. Can third parties formally oppose an application? Any person can file to oppose the registration of a trademark once it has been published in the Trademarks Journal. In order to do so, a statement of opposition must be filed along with the applicable fee. Typically, the grounds of oppositions are that the application does not comply with the technical requirements of the Trademarks Act, or the mark is not registrable under Section 12 of the Trademarks Act, which includes likelihood of confusion or descriptiveness. The applicant is not the person entitled to registration under the Trademarks Act, or the mark is not distinctive enough. The fee to file a statement of opposition to a trademark application is $750 currently. The applicant is able to file a counterclaim, and both sides are allowed to submit evidence in support of their claim. The Trademark Opposition Board is the governing body that will rule on the matter. Typically, the approximate time frame for an opposition will be 2 to 3 years in length. Pretty long. Can a mark be canceled for non-use? If so, what term of non-use applies, and what is the procedure for cancellation? A registration in Canada can be expunged for non-use. The summary expungement procedure is an administrative procedure under Section 45 of the Trademarks Act, also known as cancellation procedures. It is commenced on the request of a third party made after the third anniversary of the registration and the payment of an official fee of $400. The registrar will then issue a notice requiring the registered owner of the mark to file evidence of use or evidence of special circumstances justifying non-use. In the 3-year period immediately preceding the issuance of the notice, the registrar may also request such evidence at its own discretion. The owner of record must file evidence of use or of circumstances excusing non-use. Both parties then have the opportunity to file written arguments and attend a hearing. Given the complexities of the trademark process, you probably have a lot more questions than what we've addressed here. Enough questions to fill an entire video series on its own, in fact. That's all we have time for today, but rest assured, knowing you can always tune in next time, visit our website, or get in touch for more information. Thanks for listening, everybody.